Hashtag your constitutional rights explained simply. Hashtag legal brief. Full narration script. Every single day, millions of Americans unknowingly waive rights they didn't even know they had. They talk to police without understanding their protections. They sign away freedoms without realizing it. And they walk through life assuming that the Constitution automatically shields them from everything, when in reality, constitutional rights are far more nuanced, conditional, and sometimes fragile than most people ever learn in a civics class. Today, we are going to change that. We are going to break down your most important constitutional rights in plain, simple language, what they actually mean, where they come from, and critically, where they have real limits that could affect your life right now. The United States Constitution was ratified in 1788, but here is something remarkable: it contained almost no individual rights protections in its original form. The founders debated this fiercely. James Madison initially believed a separate list of rights was unnecessary, arguing that the structure of government itself would prevent tyranny. He was eventually persuaded otherwise, and in 1791, the first 10 amendments to the Constitution were ratified. We call them the Bill of Rights. Those 10 amendments, plus 17 subsequent amendments, form the foundation of every individual right you hold as an American citizen. What makes this document extraordinary is that it does not grant you rights, it recognizes rights that already exist and prohibits the government from taking them away. That distinction matters enormously in how courts interpret constitutional law. Let us begin with the First Amendment, arguably the most powerful and frequently misunderstood right in the entire Constitution. The First Amendment protects 5 distinct freedoms: religion, speech, press, peaceful assembly, and the right to petition the government. Most people think they know what free speech means, but the Supreme Court has spent over a century defining its precise boundaries. Here is the critical point that most people miss entirely: the First Amendment only protects you from government censorship. It does not protect you from consequences from private employers, social media platforms, or other private entities. When a company fires someone for their social media posts, that is not a First Amendment violation. The government did not silence them. A private actor did. Constitutional rights, with very few exceptions, only restrict government action. The Supreme Court has also ruled that certain categories of speech receive no First Amendment protection at all. True threats, incitement to imminent lawless action, defamation, and obscenity can all be legally restricted. The famous "you can't yell fire in a crowded theater" principle, though often misquoted, captures this idea: speech that creates a clear and present danger of immediate harm falls outside constitutional protection. The Second Amendment gives us our next major flashpoint. The amendment reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed." For most of American history, courts interpreted this primarily as a collective right tied to militia service. That changed dramatically in 2008 with District of Columbia v. Heller, where the Supreme Court ruled 5-4 that the Second Amendment protects an individual's right to possess firearms for traditionally lawful purposes, including self-defense within the home. However, Justice Antonin Scalia, who wrote the majority opinion, explicitly stated that the right is not unlimited. Prohibitions on carrying firearms in sensitive places, restrictions on felons and the mentally ill, and regulations on commercial sale all remain constitutionally permissible. The debate around the Second Amendment continues to be one of the most legally contested areas of constitutional law today. The Fourth Amendment is perhaps the one that affects ordinary Americans most frequently during daily life. It protects against unreasonable searches and seizures and requires that warrants be supported by probable cause. What this means practically is that police generally cannot search your home, your car, or your person without either a warrant or specific circumstances that justify an exception. The exclusionary rule, developed through cases like Mapp v. Ohio in 1961, means that evidence obtained through an unconstitutional search generally cannot be used against you in court. However, the exceptions to the Fourth Amendment warrant requirement are extensive. Consent searches, plain view doctrine, exigent circumstances, search incident to arrest, and the automobile exception are just a few of the ways courts have allowed warrantless searches. Understanding these exceptions is not just academic. If you are ever stopped by police, knowing that you have the right to refuse consent to a search could be one of the most practically valuable pieces of legal knowledge you ever encounter. The Fifth Amendment contains some of the most famous language in constitutional law. It protects against self-incrimination, double jeopardy, and guarantees due process of law. When someone says they are pleading the Fifth, they are invoking their Fifth Amendment right to refuse to answer questions that might incriminate them.
This right applies in court, during police questioning, and even in congressional hearings.
The double jeopardy clause prevents the government from trying you twice for the same crime after an acquittal or conviction. However, it does not prevent both state and federal prosecutions for the same conduct, a nuance that came into sharp focus during several high-profile civil rights cases in the 1960s, where federal charges followed state acquittals. The Sixth Amendment guarantees the right to a speedy and public trial, an impartial jury, the right to be informed of charges, the right to confront witnesses, and critically, the right to counsel. The landmark 1963 case Gideon v. Wainwright established that if you cannot afford an attorney in a felony case, the government must provide one. Clarence Earl Gideon, a Florida man who had been convicted without representation, wrote a handwritten petition to the Supreme Court from his prison cell. The court ruled unanimously in his favor, transforming the American legal system and establishing public defenders as a constitutional necessity. This right to counsel is one of the most practically significant rights you possess. Exercising it the moment you are arrested can make an enormous difference in the outcome of your case. The Eighth Amendment prohibits cruel and unusual punishment and excessive bail. Courts have interpreted this to mean that punishment must be proportional to the offense. The death penalty has been challenged extensively under the Eighth Amendment. The Supreme Court has ruled that executing individuals who committed their crimes as minors is unconstitutional, as is executing individuals with intellectual disabilities. The amendment has also been used to challenge prison conditions, solitary confinement policies, and the methods used in executions. This is an area of constitutional law that continues to evolve as societal standards of decency shift over time. The Supreme Court has explicitly said that Eighth Amendment interpretation must account for the evolving standards of a maturing society. The 14th Amendment deserves special attention because it fundamentally transformed how constitutional rights work in America. Ratified in 1868 after the Civil War, its Due Process Clause has been interpreted by the Supreme Court to incorporate most of the Bill of Rights against state governments. Before the 14th Amendment, the Bill of Rights only restricted the federal government. States could theoretically do whatever they wanted. Through a process called selective incorporation, the Supreme Court has applied almost all of the first 8 amendments to the states through the 14th Amendment's Due Process Clause. This means your First Amendment rights protect you from your state government just as they protect you from the federal government. The 14th Amendment's Equal Protection Clause has been equally transformative, forming the constitutional basis for landmark decisions on racial segregation, gender discrimination, and marriage equality. There are also rights that many people believe exist in the Constitution but technically do not appear there explicitly. The right to privacy, for example, is nowhere written in the text. Yet the Supreme Court has recognized a constitutional right to privacy derived from the First, Third, Fourth, Fifth, and Ninth Amendments, as well as the liberty interest protected by the 14th Amendment. This right formed the basis for decisions on contraception, abortion, and intimate personal choices.